Peace, peace, peace. Happy Monday, everyone. Happy Monday. It is your girl, Empress ShayMarie. Let me share this out right quick. Press mute. Grand Rising, everyone. Today is June 27th, 2022, according to the Gregorian calendar. So, welcome, everyone. Happy Monday again. Moon Day. Let me know if you all can hear me. I'm using a headset. I'm using a new headset, and I don't know if I can be heard. So let me know in the chat how y'all doing today. We got one person in the building. Welcome to you, whoever you might be. Give me a moment. I'm still sharing this out to my platforms. So make sure you share this out to your people. Hey, Wow Indian, how are you, love? Grand Rising. I need to make you I need to make more people moderators. Probably won't be able to do it. Let me see. I'll probably have to do it after the video. So I have to stop the music for a moment. I'll probably have to do it. Okay. Let's make Wild Indian a moderator. All right. I made you a moderator, Wild Indian. I'm doing great. Doing wonderful. In spite of all the tests and trials that come to get us off our square, I'm doing absolutely wonderful. I cannot complain. I'm thankful to the universe, happy and grateful that I've been given another day to continue on this journey, because it is definitely a journey. So let me get my music back on. So we're going to continue today with the reading from the 0%. Yesterday we stopped on chapter 2. We ended on chapter 2. So we're going to pick up today on chapter 3. Okay. So give me a moment to locate the chapter. We did pretty good yesterday with the reading. I can say I was very pleased with the information and with my comprehension of what was being said. Not too much surprise. Some of the information was surprising to me. I probably heard it before, but reading the book, it brought up a different understanding. So let's see here. Let me get back over here. Now, gratitude to you, Wow Indian Roots. Thank you for accepting the charge. Okay, so we're going to get started with chapter 3 today, you guys. Just trying to make sure I'm focused here. All right. So, chapter 3 existence of life. It says the origin of the all capital letter fiction, the ens legis or legis, that the United States created began in London in 1666. The ens legis is the same name as the natural physical person. It has a dual nature or two sides of the same coin. They're very similar to the two sides of a standard checking account, a debit and credit side of the ledger. The all capital letter John Doe Smith is the legal fiction, corporation, debtor. And the all capital letter Smith John Doe is the natural physical person or creditor. In today's commercial system, the debtor side is utilized for every commercial transaction in public. The ens legis began during the Black Plague and Great Fires of London. Parliament enacted an act behind closed doors, unknown to the people, called the Cestui Que Vie Trust or Act of 1666. The year is by no accident being reminiscent of the book of Revelations, chapter 13, verse 16 through 18. And he causes all, both small and great, rich and poor, free and bond, to receive a mark in their right hand or in their foreheads, and that no man might buy or sell he that had the mark, or the name of the beast, or the number of his name. Here is wisdom. Let him that hath understanding count the number of the beast, for it is the number of a man, and his number is 636. King James Version. 636 are the coded numbers the ruling governments will ultimately use to identify their citizens for total control. The act being debated was to subrogate men and women's rights, meaning all men and women were declared dead, lost at sea from the law of admiralty law. The state, London, took custody of everyone and their property into a trust. The state became the trustee or husband, holding all titles to the people and property until a living man returns to reclaim those titles. He can also claim damages. The all capital letter name, legal fiction, or fictitious name is owned by foreign governments on the same footing with the likes of owning a share in the stock market. To own a percentage, but it is still a share of the stock. Its Latin name, ens legis, meaning a creature of law, an artificial being, as contrasted with a natural person, applied to corporations, considered as deriving their existence entirely from the law. Black's Dictionary, second edition. One moment, everybody. I gotta get this background noise out from behind me. Okay. My apologies. All right. As of today, in the year 2021, all ens legis public debt is circulated at a staggering 22 trillion, to which 12 countries have a share of the stock in the United States corporation. Number one is China at 1.11 trillion, holding 17.3%. Second is Japan at 1.06 trillion, holding 16.5%. Third is Brazil at 307 billion, holding 4.8%. Fourth is the United Kingdom at 301 billion, at 4.7%. The fifth is Ireland at 270 billion, holding 4.2%. Sixth is Switzerland at 227 billion, holding 3.5%. Seventh is Luxembourg at 224 billion, holding 3.5%. The eighth is Cayman Islands at 217 billion, holding 3.4%. Ninth is Hong Kong at 206 billion, holding 3.2%. The 10th is Belgium at 180 billion, holding 2.8%. The 11th is Saudi Arabia at 177 billion, holding 2.8%. And the 12th position is Taiwan at 171 billion, holding 2.7 share of stock. All 12 countries are dominions of Morocco, Mohammedan nation. Their stock shares are truthfully in the Sultan's hands, headquartered in the finance capital of the world, New York City. London is an independent city-state controlling the world's banking system. The Vatican is an independent city-state controlling the world's religious structure and corporate souls. Washington, D.C. is also an independent state, controlling the Earth military, and the Crown is an unincorporated association to be private. The Temple Bar is in London, and every lawyer called to the bar swears allegiance to the Temple Bar. By becoming the executor of the fictitious name and collapsing the Cestui Que Vie Trust, one can reclaim their property and compensation for damages. It takes a trust to collapse another trust in a court of equity or chancery. Until this process is complete within the court, citizens will always need representation when involved in legal matters because the fictitious name is pronounced dead and lost at sea. Legal fictions are a construct on paper and estate in trust. When a legal person receives a summons from a court, it is always addressed in the fictitious person in the all capital letter, since as first, middle, and last, or last, first, middle, similar to tombstones in graveyards. Capital letters signify death. A fictitious legal person is created when someone informs the government that a new vessel has arrived upon birth. Birth certificates are issued to the government by the dock, just as ships are given birth certificates at the dock. It's all about commerce. Newborns are delivered through their mother's water, a birth canal, just like a ship. The ship is moved by the current, guided by the river banks, and the currency moves the lives of all persons through the banks. Parents register the birth of their babies unknowingly entering them into the matrix of admiralty law. In 1837, the Births, Deaths, and Marriages Act were formed in the UK, and the post of Registrar General was established. His job was to collect all the data from the churches, which held the records of birth. Regis, meaning from the Queen or Crown, all people are seen to be in custody of the Crown. This allows people to function in commerce and to accept the benefits provided by the state. A Cestui Que Vie Trust, known later as a fiat commissary trust, and also referred to as a secret trust or as secret trust, is a fictional concept, being a temporary testamentary trust first established during the reign of Henry VII of England through the Cestui Que Vie Act of 1540 and updated by Charles II through the Cestui Que Vie Act of 1666, wherein as an estate may be affected for the benefit of one or more persons presumed lost or abandoned at sea, and therefore presumed, quote unquote, dead after 7 years. Additional presumptions by which such a trust was added in later statutes to include bankrupts, minors, incompetents, mortgages, and private companies. The original purpose and function of a Cestui Que Vie Trust were to form a temporary estate for the benefit of another because some event, state of affairs, or condition prevented them from claiming their status as living, competent, and present before a competent authority. Therefore, any claims, history, statutes, or arguments that deviate in terms of a Cestui Que Vie Trust's origin and function as pronounced by these canons is false and automatically null and void. A Cestui Que Vie Trust may only exist for 70 years, being the traditional accepted life expectancy of the estate. In 1534, before the first Cestui Que Vie Act, 1540, Henry VII declared first Cestui Que Vie type estate with an act of supremacy, which formed the crown estate. 1770 years later, in 1604, James I of England modified the estate as the Union of Crowns. The crown was viewed as a company by the 18th century. However, at the beginning of the 19th century, the company filed bankruptcy in 1814. It became a private crown corporation controlled by wealthy European banker families who obtained their wealth through intermarrying with high status Moors. Since 1581, there has been a second series of Cestui Que Vie estates concerning the property of persons and rights which migrated to the United States for administration, including in 1651, the Act for the Settlement of Ireland, 1651 through 52, introduced the concept of settlements, enemies of the state, and restrictions of movement in states of emergency. In 1861, the Emergency Powers Act 1861, and in 1931, the Emergency Relief and Construction Act 1931 through 32, and in 2001, the Patriot Act 2001. Since 1591, there has been a third series of Cestui Que Vie estates concerning the property of soul and ecclesiastical rights, which migrated to the United States for administration, including in 1661, the Act of Settlement 1661 through 62, and 1871, the District of Columbia Act 1871, and 1941, the Land Lease Act of 1941. All birth certificates, and stock certificates are indeed certificates of title. All include stock on banknote numbers referring to a bond pending a mature date. Black's Law Dictionary, second edition, defines certificate of title as this document certifies ownership of real property or a vehicle. An authorized agency will capture a description of the property and the liens on it on the issued certificate. A certificate of title is vastly different from the word entitled, meaning to give a right or title to one who has a right to property in ordination as a minister in ecclesiastical law. Black's Law Dictionary, second edition. A lien is always displayed on a certificate of title and never to one who possesses entitlement to a title. This is why U.S. citizens continue to pay property taxes on houses and vehicles, regardless of a settled mortgage or vehicle sales contract, unless the property affects is registered in trust with the local ruling government. Taxes are due annually. As long as a certificate of title for an automobile exists in the all capital letter fictitious name, then the DMV remains the true lien holder. The same applies to a real property. Having a satisfaction of mortgage with a grant deed not recorded in a trust, which has a settlor, trustee, and beneficiaries. Until the house is registered in an express trust, property taxes are due annually. The beginning process of reaching the 0% tax bracket comes only by claiming one's title to remove them from being lost at sea in the law of admiralty. one must proceed with authenticating process of the birth certificate backed by the Cestui Que Vie Trust's estate assets. The following steps will include a guide to claiming the estate successfully. It begins by realizing that the birth certificate is on par with a certificate of title to an automobile or grant deed or deed of trust to real property. The purpose of authentication is given in Title 28, Judiciary and Judicial Procedure, Chapter 115, Evidence Documentary. B. Properly authenticated copies or transcripts of any books, records, papers, or documents of any department or agency of the United States shall be admitted in evidence equally with the originals thereof. Title 28 U.S. Code 1733b. Authentication of the birth certificate first begins with obtaining a certified copy of the document from the county. If issued by the Public Health Department and not the province of birth, one must first authenticate the record, obtaining a certificate of exemplification. Once received, the birth certificate with the exemplification must be mailed to the birth state Secretary of State office, requesting that the record becomes authenticated for international travel to a non-Hague Convention country, such as Thailand or Taiwan. A list of non-Hague countries is available through an internet search, and each Secretary of State office provides this service with a fee ranging from $10 to $25. The Secretary of State may take up to 30 days to process. Depending on the state, an apostille or certificate of authentication will come back attached to the birth certificate. The next step is to finalize the authentication by sending the returned birth certificate to the Department of State with their DS 4194 Request for Authentication Service form. The applicant should provide their name and mailing address in Section 1, leave Section 2 blank, and select the self-addressed stamped envelope for the delivery method in Section 3. Provide the non-Hague country in Section 4, the number of documents, which is 1, and the document type, which is the birth certificate. And finally, Section 5 must include the estimated cost, which is $8 below. I think it's $20 now, but it could be 8. So below is the Office of Authentication's mailing address, as you can see here. So you might want to screenshot that. If you're in my class, you know already. All right, be sure to include a self-addressed envelope inside the mailing packet so that the Department of State can return the fully authenticated birth certificate. Once authenticated, the document is now on par with the original certificate of live birth, which the county will never give to the rightful owner. It is now security that has been annexed from the United States, pending a claim of ownership. The final step is to attach an affidavit of ownership to the authenticated record, according to the Minnesota court rules. The Register of Titles is authorized to receive for registration and memorials upon any outstanding certificate of title and official birth certificate pertaining to a registered owner named in said certificate of title showing the date of birth of said registered owner, providing there is attached to the said birth certificate an affidavit or affiant who states that she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the Register of Titles shall treat said registered owner as having attained the age of majority at a date 18 years after the date of birth shown by the said certificate. Minnesota Court Rules, Rule 220, Birth Certificate, Task Force Comment, 1991, Adoption, 4th District, R11.05. The county assessor clerk or register clerk can receive a fully authenticated certificate of title with an attached affidavit for the sole purpose of establishing that one is no longer a minor. Until this process occurs, the government will always see the U.S. citizen as a minor, not over 18, even if the citizen is of age. The lack of proof of authentication with an affidavit proves to the government, along with the U.S. Census, driver's license, voter registration, SS5 forms, and U.S. passport applications, precisely the number of inhabitants of the age of 21 that can rightfully elect the whole number of representatives for the choice of electors in their respective state. The one named in the certificate is the one stating the claim as the registered owner. The testimony should be titled Affidavit of Claim of Ownership of Certificate of Title, and the exact wording of Minnesota Rule 2220 should be quoted in the affidavit. Here is a guide to follow. Affidavit of Claim of Ownership of Certificate of Title. I, last name, first name, middle name, doing business as your first name, middle name, last name, said affiant registered owner, being duly sworn, declare and state that I am a full age and legally competent to have firsthand knowledge of the facts stated herein, and believe these facts to be true and correct to the best of my knowledge, and that the said affiant is the same party described in the said birth certificate, real property. The attached document is authenticated. The attached document is the authenticated true copy of the original document of title, which I am the holder of the certificated title, whose name also appears on the face of the instrument as first name, middle name, last name, trust estate, by reference to the official certificate of live birth, title, warehousing receipt, recorded and filed, dated the month, day, year, which is the birth registration date, not your date of birth. So there's two different dates on your birth certificate. There's a register date, and there's your date of birth, which is the actual date that your mother birthed you into the world. Okay, or that you were born. Um, so moving on, it says, as the same appears to be held for safekeeping by your birth state, vital records, and affiant, number 2, is aware the Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title and official birth certificate pertaining to a registered owner named in said certificate of title, showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit or an affiant who states that she is familiar with the facts recited, stating that the party named in the said birth certificate is the same party as the of the owners named in the said birth certificate of title, and that thereafter the register of title shall treat said registered owner as having attained the age of majority at the date 18 years after the date of birth shown by said certificate. And 3, should any Constitution officer, whether executive, judicial, legislative, or deputy, dispute the above foresaid statement of facts, let it be known that the last name, first name, middle name is aware that her birth or breath of life dated birth month, born date, or birthday, birth year on the nation of which is your birth state, um, the territory of your birth county, and not the United States District of Columbia, and not the state of whatever state you were born in. Therefore, last name, first name, middle name, the creditor doing business as first name, middle name, last name, the debtor is a Fourth Amendment citizen known as an ens legis, created by the Certificate of Live Birth Contract in SS5 form, which by law is unconstitutional per affiant's birth state. No ex post facto law section, i.e., search the Bill of Rights or Declaration of Rights, and affiant hereby grants, convey and or give said certificate of title to the registered owner known as express trust. So you have to have a trust, whatever your trust is. The secured party further documented via a $9 billion lien substantiated by an equity procured promissory note and pledge and security agreement listed in the organic public record on the non-uniform commercial code. Any rebuttal or dispute to the above foresaid statements of facts shall provide proof that such contracts have not placed the last name, first name, middle name under legal disability, lack of legal capacity or qualification, such as that of a minor or a mentally impaired person, to enter into a binding contract per the Baby Act and per the 1877 Georgia Constitution, Article 1, Bill of Rights, Section 4, Paragraph 1. Number 4, take judicial notice. A affiant registered owner is aware that full faith and credit shall be given in each state to the public acts records and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. And 5, a affiant registered owner is aware properly authenticated copies or transcripts of any books, records, papers, or documents of any department or agency of the United States shall be admitted in evidence equally with the originals thereof. Proof of service. I, the undersigned, say I am over the age of 18 years and I am a party to the action or proceeding. My business address is in care of 1234 Main Street with your city in the Republic of State. So it will be in the Republic of whatever state you're in, of the United States of America. Notice how the United States is spelled. On today's date, I serve the foregoing documents described as affiant of claim of ownership of certificate of title on all interested parties, including but not limited to registrar, recorder, county clerk, name. Okay, in this action, by recording this day, the proper documents within the following offices, the full register recorder, county clerk address. The documents were served by the following means and specified. If it was by mail, I deposited such envelope in the mail at the city state with first class postage thereon, fully prepaid. I am readily familiar with the business practice for the collection and processing of correspondence for mail. Under that practice, it is deposited with the United States Postal Service on the same day at the city state, the ordinary course of business. I am aware that on the motion of the party served, service is presumed invalid if postage cancellation date or postage meter date is more than 1 day after the date of deposit or mailing in an affidavit and/or. I declare under penalty of perjury under the laws of the United States of America, 28 U.S.C. Code 1746, that the foregoing is true and correct, executed on today's date at your city and state. Put your last name, first name, and middle name, or last name, comma, first name, and middle name. The next page should be a valid state-approved notary acknowledgement signed by the notary and affiant. It is essential that the affiant always sign everything under the United States of America and not under the United States alone. Title 28 U.S. Code 1746 1 states, executed on date, signature, executed on date, signature. The difference is clear. Option 1 takes the person out. Okay, let's look at that again. Executed on date. Okay. The difference is clear. Option 1 takes the person out of the United States federal district jurisdiction. A critical portion of an affidavit is its jurisdiction distinction. Now, how exactly does one register an authenticated birth certificate with an attached affidavit? The Uniform Commercial Code gives detailed instructions regarding proper registration of any certificate of title. The process consists of perfecting one's security interests, titles, and property within the county's real estate records section, I'm sorry, or the probate section of the Superior, Circuit, or District Court. The document used is a financing statement, sometimes referred to as a UCC1. But how the material is validated before registration is the secret that leads to the 0% tax bracket. Every state has a UCC department at the Secretary of State level and also within each county municipality. The Uniform Commercial Code is a standard source of laws established by the Mohammedan nation operating under operating commerce throughout the old world. The UCC code was created because it became increasingly difficult for companies to transact business across the interstates given the various country laws. The Uniform Commercial Code is vital since it helps companies in different states to negotiate with one another by providing a standard legal contractual foundation. The laws have been fully adopted by most countries in the U.S., although there are some slight variations from country to country, states to UCC codes. The UCC codes consist of 9 separate articles. The UCC articles govern various types of transactions, including banking and loans. All lenders are supposed to perfect their contracts with their alleged borrowers using the financing statement, stating that the lender is the creditor, the borrower is the debtor, with a description of the property as collateral exercised by a lien amount. Once the debtor pays off the balance, the creditor would then remove the lien. Article 1 pertains to general provision, definitions, and specific perimeters of how the UCC is applied. Article 2 relates to the sale of goods, including real estate and service contracts. Article 3 pertains to checks, drafts, and other negotiable instruments. Article 4 pertains to bank deposits and collections. And Article 5 details the regulations of letters of credit. Article 6 pertains to the bulk sale, auctions, and liquidations of assets. Article 7 provides rules on title documents, including warehouse receipts, bulk sales, and bills of lading. Article 8 pertains to investment securities, and Article 9 states the regulations of secured transactions of personal property, agricultural liens, promissory notes, consignments, and security interests. Regarding perfecting security interests such as certificates of title, birth certificates, titles to automobiles, real property, or other personal property, Article 9 states a security interest subject to other law, except as otherwise provided in subsection D. The filing of a financing statement is not necessary or effective to perfect a security interest in property subject to 1. A statute, regulation, or treaty of the United States whose requirements for a security interest obtaining priority over the rights of a lien creditor with respect to the property preempt Section 9-310A. 2. List any statute covering automobiles, trailers, mobile homes, boats, farm tractors, or the like, which provides for a security interest to be indicated on the certificate of title as a condition or result of perfection, and any non-uniform commercial code central filing statute. UCC 9-311, A1 and 2. Article 9 states that a financing statement is not necessary to perfect a security interest or rightfully claim title unless a non-UCC is registered. The actual financing statement form has a small box selected to lawfully request and adequately register the property in the right jurisdiction. How to complete the financing statement as a non-UCC is quite simple, but first requires creating a trust, specifically an express trust. As mentioned before, trust is the only real entity as government truly respects as a natural person because it is a trust that further creates private corporations. Every other entity is viewed as a dead fictitious corporation, corpse. To take part in the 0% tax bracket, a foreign trust must be the foundation of any person or business in the form of a holding trust. If John Doe works for Walmart Inc., a foreign express trust must be the foundation holding all of John Doe's assets, including its income from Walmart. If John Doe starts a mobile car wash business named Mobile Cleaning LLC, a foreign express trust must be the foundation and owner holding all the LLC business assets as collateral. A foreign express trust must have a foreign trustee and not a domestic trustee. To have a domestic trustee would ultimately give the United States control over the trust at all times, which can then be taxed and controlled. A foreign trustee means anyone who does not have a United States green card, United States of America birth certificate, certificate of citizenship or naturalization, Social Security number, or ITIN. The trustee must have a foreign country passport identifying the IRS or any United States court, the trust jurisdiction. Without a foreign trustee, obtaining the goal of operating in the 0% tax bracket is impossible. To complete the financing statement as a non-UCC is as follows. Note, upper and lowercase spelling is necessary for box B, okay, which is your name. U/D is your name of trust, express trust, and then it'll be in the care of your mailing address, Chino Hills, California, with your zip code in brackets. Section 1A will say your first, middle, and last name. Section 1C is the address of your county courthouse. Okay, so your county courthouse would be the address of for your first and your first, middle, and last name for 1A. Okay, Section 2B is the last name and first name, last name, comma, first name. Section 2C is the address of Berth County Courthouse. Section 3A is the foreign trustee name or trustee under declaration of name of trust, express trust DTD, date of trust, created. Okay. Section 3C will be your foreign mailing address. With trust is Section 4. Constructive notice that all of debtors, every derivative of the name, interest in certificated securities, note include Department of State authentication number, top of gold document authenticated certificated security number, note birth certificate number, uncertificated securities, showing the last four of your social security number, as you can see here, and including licenses, permits, insurance contracts, commodities, accounts, public and private, all assets, all personal property or properties, whether tangible or intangible, and real property or properties forever and fee simple, is now owned and held in covenant by the trustee for the beneficial owner herein, known as the name of the trust, express trust, DBA, name of the trust. Okay, let's go back up here. Okay. Exhibit 1.23, equity secured promissory note. For valued received debtor, the borrower promises to pay the order of name of trust, express trust, herein known as lender, the secured party, in lawful money of the United States, the principal sum of $9 billion, secured by your last name, comma, first name, middle name, first middle name, for a loan received by the express trust. Okay. Exhibit 1.23.4 is going to be a pledge and security agreement entered into as of the month, date, and year by and among the first name, middle name, and last name, who is the borrower, and the name of the trust, express trust, who is the creditor, for itself as the secured party. Section 5, going to say you're going to check box, which will be held in the trust. Section 6A, you're going to check box public finance transaction. Section 6B, you're going to check box non-UCC filing. And then section 7, you'll leave blank. The final step in completing a financing statement is to draft the actual financing detail for the express trust to place a legitimate lien on the ens lega's birth name. It must have a note followed by a security agreement to which the ens legas has received a loan from the trust as its creditor and promises to repay the loan listed as a borrower. In this case, the trust loaned $9 billion to the ens legas, first name, middle name, last name, secured by the labor and energy of the real man, which would be your last name, comma, first and middle. Ever since birth, the county, state, courts, banks, and District of Columbia have created notes against the ens legas without the real man's consent, estimating how much money could be generated and circulated in the economy backed by the real man's labor. The trust, as a creditor, must do the same, securing a $9 billion note, allowing the trust to have the first lien position of all property in the name first, middle, and last. This is the same procedure when it comes to financing a house with federal government-backed security. The deed of trust or warranty deed security agreement is secured by the borrower's promissory note or your 1003 mortgage application form. If a borrower undergoes a foreclosure, the bank must legally record the amount loaned via a non-UCC to substantiate their right to a first position lien on the property seeking satisfaction of a debt before any other potential creditor in pursuit of equity. The UCC, with the promissory note and security agreement, including the authenticated birth certificate with the attached affidavit of claim of ownership, must be sent to the applicant's first county recorder's office. The birth county recorder's office and the county recorder's office where the applicant is doing business. Some states and counties are more complicated than others because officials know the applicant's intentions and the process's power. No owner wants to free their voluntary slave from the matrix. It should take anywhere from a month or two for the financing statement to return. Section 4 pertains to all collateral in the debtor's name owned by the express trust. In trust law, the goal is to control everything but own nothing. The language is in section. Hold on 1 second, guys. Oh. Okay. The language in section 4 covers all accounts listed in the name of the social security number, such as bank accounts, business accounts, DMV applications, and the like. Okay. After the county recorder records the non-UCC, it must be recorded with the Secretary of State as a notice of lien. To do this, the very same financing statement form is used. Almost all of the information will remain the same except box 4 and box 6B Box 4, the collateral will only state the county's clerk of court regarding information such as file number, book number, deed number, dates, and page count. Box 6B will say is the non-UCC filing will be left unchecked. Okay, this will ensure that the financing statement will file as a UCC1 notice of lien. Okay, for all corporations to take equitable notice. Got it. In addition to receiving a certified copy of the UCC1 and both non-UCCs from the birth county and applicant's business county, filing UCC 11 debtor search with the Secretary of State will provide proof that the express trust is the only creditor of the ens legis and its $9 billion lien holds first position. All creditors thereafter must obtain permission from the express trust. The debtor search certificate can now supply the natural person or trust the admissible evidence to challenge alleged creditors such as lenders holding mortgages or electronic liens held at the Department of Motor Vehicles. Lenders of today operating in public, such as banks after the United States bankruptcy of 1933, are indeed alleged creditors because no corporation or its agencies can lend money, credit, or, in other words, valuable consideration when it is currently bankrupt. Banks can only act as pass-through agent to deliver funds. When an applicant provides his name and social security number or ITIN, the alleged lender routes the application to one of the 12 Federal Reserve banks to wire the funds back to the pass-through agent in exchange for bank credits. Each SSN ITIN acts as a checking account number, while the number on the back of the Social Security card acts as a Federal Reserve Bank routing number. A letter is referenced on the back of each SSN ITIN card describing the bank or origination, such as first, Bank of Boston, where with the letter A. Second is Bank of New York with the letter B. Third is Bank of Philadelphia with the letter C. Fourth is Bank of Cleveland with the letter D. Fifth is Bank of Richmond with the letter E. Sixth is Bank of Atlanta with the letter F. Seventh is Bank of Chicago with the letter G. Eighth is Bank of St. Louis with the letter H. Ninth is Bank of Minneapolis with the letter I. And the 10th, Bank of Kansas City with the letter J. 11th, Bank of Dallas with the letter K. And the 12th is Bank of San Francisco with the letter L. One enormous benefit of operating in a trust is that it allows the creditor to collapse the 14th Amendment trust. The 14th Amendment certificated and uncertificated securities tied with the Securities and Exchange Commission can then be released to the creditor. This process can be done repeatedly with the wealthiest this process has been done repeatedly with the wealthiest families worldwide, and the Uniform Commercial Code gives its instructions. It says D, the interest of a debtor in a certificated security for which the certificate is in the possession of a secured party or an uncertified security registered in the name of a secured party, or a security entitlement maintained in the name of a secured party may be reached by a creditor by legal process upon the secured party. Uniform Commercial Code 8-111, Creditors Legal Process. I'm going to take a drink of water right quick, you guys. So give me a moment, please. How y'all doing in the chat? All right, I see all my peoples in the building. Peace, Mr. Somebody. Peace, Mother Vicky. Peace. What's up, Benny Cash? What y'all up to today? Thank all of y'all for joining me. This is definitely a good read. Very informational, very informal. I'm definitely enjoying it. I can't wait to play it back. Hope you all are taking notes. All right, let's get back to the reading. All right. The express trust is the creditor over the debtor, all capital letter name, and takes ownership of everything the debtor could never own and thus becomes the secured party. The birth certificate is the certificated security, which is in the trust's possession after its authentication process. The certificated security backed by the estate is the foundation for the United States, creating the Social Security benefits, which is the uncertificated security, now registered in the secured party's name via the non-UCC. The applicant would then petition the court to affix a new name onto the birth certificate, particularly a name recognized with the high status of title of nobility. So as the applicant would then petition the court to affix a new name onto the birth certificate, particularly the name recognized with the high status title of nobility that the UCC government is fully aware of. For example, the United States citizen known as John Doe Smith of the John L. Express Trust should seek a name change to John Doe L. John Doe L is the name that does not have a social security number or was never registered as a debtor in the United States Private Corporation Trust, which substantiates its commercial status as a creditor and not a debtor slave. The title of L belongs to the lineage of the Moors, i.e., Black or African American, and its inheritance is held in trust just waiting to be claimed. The same applies to English noble titles such as Baron, Duke, Marquis, Viscount, or Senior, or Lord. The Express Trust could then enter a court of equity and file a suit against the county where the former John Doe Smith fictitious ens legis was created to collapse the 14th Amendment trust, terminating all intermediary fiduciaries managing the trust fund. The Express Trust trustees would then receive all of the monetary securities in the debtor's name on behalf of the beneficiaries. In addition to the name change, the true race of the Moor or foreign nation would be affixed to the birth certificate via vital statistics, allowing the trustee to petition the court to release all descendable funds in the name of the debtor's forefathers and foremothers. A certificate a certified genealogical blood record would be necessary as admissible evidence to the court. Wealthy families utilize the express trust and the tools provided in probate court, referenced to as the King's Court, to fund their trust and intergenerational wealth. Now, let me read the last little sentence again. It says, a certified genealogical blood record would be necessary as admissible evidence to the court. Wealthy families utilize the express trust and the tools provided in probate court, referred to as the King's Court, to fund their trust and intergenerational wealth. Okay. So that was chapter 3, you guys, and we've been on for an hour. I can go longer if you guys want me to. Let's go back over here to the chat. Albert Taylor says, welcome. Thank you for reading. If you wanted to buy this book, you just to be sure, I found something on Amazon. Yeah, it's already in my link, Albert Taylor. Thank you for your help, but we already got that covered, okay? I already got that covered. Thank you for your non-solicited help, however. If you wanted to... Okay, chosen. So guys, the link, if you want to purchase the book, I have the link to all my suggested books in the description area of this video, okay? All right. Let's see. Chosen to read. Much respect. Well, thank you, Coke Giles, Zachary Shaman McLeod. That's a long ass name, but thank you. It's funny because many people, my godfather told me a long time ago that I should look into using my voice, um, using my voice as my gift. I'd also sing, but he also told me about like reading and stuff like that. So when I was going to church, I would be one chose to read. However, I would always stumble over words, kind of like what I'm doing now, but I'm getting a whole lot better because I'm practicing. So I appreciate that. I was thinking the same thing. I was reading. I'm like, I feel like I'm getting better with my reading, the more I do it. So I definitely appreciate that. I'm definitely working on perfecting the stumbling of words and stumbling over stuff. Sometimes it's just my eyes seeing what it doesn't really see. So maybe I need to get some glasses. I don't know, but I can see perfectly good, honestly. So if you guys want me to continue on with chapter 4 for another hour, let me drop a 9 for those 9 ether beings. Drop a 9 in the chat for me. We got 13 people in the building. I don't know. Make sure we get those likes up. Practice makes perfect. Absolutely. So I absolutely appreciate that that confirmation. I appreciate that. That means we kind of in sync with the universe, and whatever the universe is leading me to do, that's all I'm continuing to do. And just put my best foot forward and continuing to enlighten people and bring this information to the light, because there are gatekeepers that are trying to keep this knowledge from us and keep us from uh, obtaining our trust, obtaining our estate. All right, so we got 3 9 so far, I see. All right, y'all. Okay. So that's why I'm doing this, and I got a lot of people backing me. I've been a rebel all my life, y'all, and I'm walking more so in that rebellion now. I've always been kind of afraid because of the my Christian upbringing and that fear that was kind of instilled into me. But I'm shaking all that fearful shit off of me day by day and getting more in tune with the truth and with myself. So I appreciate all of you all. We're gonna go for another hour, because this definitely is a good read. I might agree. So moving on. Um, Chapter 4, persons not required to file. Internal Revenue Service, as you see in the description. The illustration. Before I continue, let me grab one more glass of water, guys. How about we all 9 billionaires? It's probably worth more than that, but I'll take the 9 billion. Shit, give me my 9 billion. Okay. Even though it's supposed to be unlimited, honestly. But I'll take the 9 billion. There's a lot I can do with that. Save a lot of people. Help a lot of family. For sure. All right. So let's get to it. By now, it may be clear who is required to file a 1040, a 1041, or a 1065 tax return statement, and who is not required to file. If not, then the best source is the Internal Revenue Manual, IRM, which is also codified in Title 26, Internal Revenue Code. Let their words reveal how wealthy families have obtained prosperity over a century. An interesting fact about taxes is the actual definition of the word in Title 31, Money and Finance. D1. The Secretary of the Treasury may accept, hold, administer, and use gifts and bequests of property, both real and personal, for the purpose of aiding and facilitating the work of the departments of the Treasury. Gifts and bequests of money and the proceeds from sales of other property received as gifts or bequests shall be deposited in the Treasury in a separate fund and shall be dispersed on order of the Secretary of the Treasury. Property accepted under this paragraph and the proceeds thereof shall be used as nearly as possible in accordance with the terms of the gift or bequest. 2. For purposes of the federal income, estate, and gift taxes, property accepted under paragraph 1 shall be considered as a gift or bequest to or for the use of the United States. Title U.S. Code 321, General Authority of the Secretary, D1 and 2. Taxes are indeed voluntary. They are not needed to run the government and the services Americans use on a day-to-day basis. All taxes acquired from real property, meaning real estate, and all taxes acquired from personal property, whether tangible or intangible, meaning Social Security numbers, stocks, shares, etc., are considered gifts to Washington, D.C. Let me pause right there because about 3, maybe 4 years ago, my mom's best friend, Grandma Cynthia, I call her. She's like a grandmother to me. Was like, well, isn't the taxes? Shouldn't we be paying the taxes to help with the roads and the pavements? I'm like, I was well before my time, you guys. I just didn't have the confidence in what I kind of was naturally knowing, but I just had a knowing. Man, it's just so crazy, like how the revelations. I've been saying, like, this is a year of revelation and restoration, and man, things are definitely moving. So there is no need to transfer all hard-earned wealth to the United States corporation when its only motive is inflating the dollar and controlling as many alleged citizens as possible through deceptive voluntary contracts. Before diving into the IRM, understanding how the fraud of being classified as a domestic U.S. citizen and not being recognized as a countryside national is paramount. Each state is its own country. Therefore, being born in Oregon state makes the newborn an Oregonian national per the 2016 GPO style manual, page 95. Parents have unknowingly provided evidence that their offspring is a federal district franchise such as Black, African American, White, Asian, Hispanic, American Indian, Latino, Alaskan, or Pacific Islander, including evidence stating that their offspring were born in a zip code. The District of Columbia deems the child lost at sea, abandoned, and stateless. This unconstitutional act by the District of Columbia is an act of paper genocide, which is described as the deliberate and systematic destruction of Native American Indian culture, language, and identity as a unique racial group by way of illegal and oppressive race reclassification imposed on Native American Indians or Blood Indians to the non-Indian races of Black, African American, White, or Latino, Hispanic. With the stroke of a pen or the click of a mouse, Native American Indian ancestry can be suppressed on government records. The United States Supreme Court struck down Walter Plecker's Racial Integrity Act in 1967 within Loving versus Virginia, Urban Dictionary. The affidavit of claim of ownership of certificate of title template mentions in Section 4 the full faith and credit clause from the United States Constitution, Article 4, Section 1. It means that any law or record in one state shall be applied in any other country's state. Observe the 1877 Georgia Constitution, Article 1, Bill of Rights, Section 4, Paragraph 1, which is law in every other state. Laws of a general nature shall have a uniform operation throughout the state, and no special law shall be enacted in any case for which provision has been made by an existing general law. No general law affecting private rights shall be varied in any particular case by special legislation, except with the free consent in writing of all persons to be affected thereby, and no person under legal disability to contract is capable of such consent. The latter of this law explains that each person must consent to any contract they have willfully agreed to, and no person under legal disability can consent to such an agreement. The definition of legal disability is defined: lack of legal capacity or qualification, such as that of a minor or a mentally impaired person, to enter into a binding agreement. Business Dictionary. In this case, all Americans are not have never been U.S. citizens. The District of Columbia is committing fraud by contracting with infants who are incompetent of entering into legally binding contracts. Which contract? Their certificate of live birth, to be exact. By issuing a birth certificate, an American can voluntarily apply for a social security number, register to vote, apply for a driver's license, apply for a USA passport, or life insurance. However, the mother and father or legal guardian submitted the information on behalf of the infant to the county or province registrar to create a contract. It is against the 1877 Georgia Constitution and every other constitution. Its law holds uniformity in all other states as well. Everyone is a national because the United States is located in the 10 square mile radius known as Washington, D.C., permitted by the Organic Act of 1871. Therefore, all nationals are foreign to the United States. All Americans are lawfully placed in the category of a plea of infancy, known as the Baby Act. Plea of infancy, interposed for the purpose of defeating an action on a contract made while the person was a minor, is vulgarly called pleading the Baby Act. By extension, the term is applied to a plea of the statute of limitations. Baby Act, Black's Law Dictionary, second edition. Baby Act and legal disability are major lawful components to being recognized as nationals by birthright. Would it mean that all contracts in the all capital letter first, middle, last name, or last comma first middle name fictitious name considered invalid contracts? Contracts require one to be a U.S. citizen to be approved for financings such as mortgages, auto loans, student loans, and more. What would happen to these obligations if a national claimed their estate, removing the estate from the 14th Amendment trust into an express trust, and the express trust sued the alleged lien holder based upon an invalid agreement? Would all false financial obligations be discharged? The true location and meaning of the United States are the 10 square miles of Washington, D.C. Most American nationals born outside of that radius are foreign to domestic United States concerning their country. Discovering how the Internal Revenue Manual determines who is required to file income tax returns is not simple. Regardless of the entity type, as an individual or a business, first analyze how an employee or a business owner can set up a foundation to enter the 0% tax bracket. Section 21.7.13.3.2.7 subsection 2 states: telephone calls from foreign entities requesting an EIN, employer identification number, are assigned IEN prefix 98 and are only worked by Cincinnati and Ogden internal units. If a call is received in any other location, provide the caller with the EIN international phone number 267-941-1099, not a toll-free number. Hours of operation 6 a.m. to 11 p.m. Eastern Time, Monday through Friday. EIN international fax number is 855-215-1627 if faxing from within the United States, and EIN international fax number 304-707-9471 if faxing from outside of the US. Okay? You guys getting it? Anyone may use any of these options to set up their foundation. However, calling to speak to an agent is the fastest method. So, what exactly is the foundation that needs to be acquired to achieve a tax-free lifestyle? Well, according to the Internal Revenue Code 7701 definitions, the term domestic, when applied to a business entity, means created or organized in the United States or under the law of the United States or any other state or of any state, unless in the case of a partnership the secretary provides otherwise by regulations. A business entity or organization or organized both in the United States and in a foreign jurisdiction is a domestic entity. The term foreign, when applied to a corporation or partnership, means a corporation or partnership with which is not domestic. The term domestic trust means a trust in which a court within the United States is able to exercise primary supervision over the administration of the trust, and one or more U.S. persons have the authority to control all substantial decisions of the trust. The term foreign trust means any trust other than a domestic trust described above. IRS Manual 21.7.13. The term domestic estate means any estate other than a foreign estate. IRS Manual 21.7.13. The term foreign estate means an estate the income of which from sources outside the estate, which is not effectively connected with the conduct of a trade or business within the U.S., is not included in gross income under subtitle A of Title 26 of the U.S. Code. Notice the IRS is very descriptive with terms describing domestic, but not so much with foreign terms, other than it is the opposite of domestic. As nationals, the people of the United States of America are foreign to the domestic U.S. Therefore, it is imperative to set up a foreign trust as the foundation to hold all assets. The golden rule of trust is to own nothing but control everything cannot be stressed enough. This means that a foreign trust will own all of the earnings from employment or the earnings generated from business practices. Regarding the earnings from an employer, a Social Security number or ITIN, uncertificated security, was given to the employer via IRS Form W-4 to begin working as an employee. To remove the obligation of federal and state taxes from each employee's paycheck, first convert the uncertificated security SSN ITIN from a domestic estate to a foreign estate, as mentioned above. The foreign estate will be housed under the foreign trust for total tax exemption through the trustee, alerting the employer to no longer provide payment in the domestic estate name, but now in the foreign trust. All foreign trusts seeking lawful tax exemptions use the IRS Form SS4 to receive an IEN assignment 98 prefix number from the IRS, and it must be done over the telephone. If the foreign trust receives any number other than the 98 prefix, the process must be completed repeatedly until it is received. Here are all of the reasons the IRS will assign IEN 98 prefix number by the Cincinnati or Ogden campus. A corporation or limited liability company indicates on line 9B that it was incorporated in a foreign country. There is language anywhere on form SS4 suggesting foreign status such as tax treaty, foreign entity, treaties or Treasury Reg 1.1441-1E48. Okay. 8971 election, Form 1120F, Form 5471, Form W8I or 1M or IMY, Form 8EXP, and Form W8BEN. An entity checks the box on line 10 for compliance with IRS without withholding regulations. Okay, so you want to check box 10. Or if you're on the phone, you want to tell them that compliance with IRS without regulation, without or compliance with IRS withholding regulations. Okay, the IRS form SS4 must have the above information detailed on the form given to the IRS agent over the telephone to receive their IEN number or foreign number to own everything in a trust held by the trustee successfully. An employee trading hours for dollars becomes liable to pay all forms of taxes, of course, from using the uncertificated security as a domestic estate and failing to provide the employer with consent that the employee agrees for taxes to be withheld from their earnings. The IRS Form W4 is simply not a complete valid consent. The law requires that all employees furnish a separate statement in writing to be attached to the W4. How many employers follows this imperative rule? Most would agree, not many, and therefore many employers face a legitimate lawsuit for not providing the information upfront with the new hire employee. This is another deceptive tactic that the United States uses to entrap nationals into voluntary servitude. Many employees or employers would rather not hire the new employee when presented with such a statement out of fear of dealing with the IRS. If the statement is addressed to the employer from the trustee's attention of a foreign trust, then the responsibility of reporting tax exemptions would be in the hands of the IRS and not the employer. The foreign trust is the only entity the IRS respects because it is viewed as a natural person and outside of their jurisdiction. Title 26 CFR 31.3402, page 1, voluntary without withholding agreement states. A. Employer-employee agreement. An employee and his employer may enter into an agreement under Section 3402, page 3, A, to provide for the withholding of income tax upon payments of amounts described in paragraph B1 of 31.3401, A3, made after December 31st, 1970. An agreement may be entered into under this section only with respect to amounts which are includable in the gross income of the employee under Section 61 and must be applicable to all such amounts paid by the employer to the employee. The amount to be withheld pursuant to an agreement under Section 3402 P3, all shall be determined under the rules contained in Section 3402 and the regulations thereof. C 31.3405 C-1 Q&A -3 concerning agreements to have more than 20% federal income tax withheld from eligible rollover distributions within the meaning of Section 402. B. Form and duration of the employer-employee agreement. 1. Except as provided In subdivision 2 of this subparagraph, an employee who desires to enter into an agreement under Section 34 P3A shall furnish his employer with Form W-4 withholding exemption certificate executed in accordance with the provisions of Section 3402 and the regulations thereunder. Furnishing of such form shall constitute a request for withholding. In the case of an employee who desires to enter into an agreement under Section 3402 P3A with his employer, if the employee performs services in addition to those to be the subject of the agreement, the remuneration for which is subject to mandatory income tax withholding by such employer, or if the employee wishes to satisfy that the agreement terminate on a specific date, the employee shall furnish the employer with a request for withholding, which shall be signed by the employee and shall contain A, the name, address, and social security number of the employee making the request, B, the name and address of the employer, C, a statement that the employee desires withholding of federal income tax and applicable of qualified state individual tax, see paragraph D3, 1 of subsection 3101.3, 6361-1 of this chapter, regulations and procedures and administration. And if the employee D desires that the agreement terminate on a specific date, the date of termination of the agreement. Okay. If accepted by the employer as provided in subsection 3 of this subparagraph, the request shall be attached to and constitute part of the employee's Form W-4. An employee who furnishes his employer request for withholding under this subdivision shall also furnish such employer with Form W-4 if such employee does not already have a W-4 in effect with such employer. Instead of providing an employer in a statement attached to Form W-4 as a domestic estate, a foreign estate should be provided on behalf of the foreign trust via an assignment notice to the employer Human Resources Department. All employees who do not provide a statement as required in Section C as a foreign estate qualifies their wages as effectively connected with the conduct of a trade or business with the United States, and therefore taxes at the highest tax bracket to convert a domestic estate, SSN or ITIN, into a foreign estate. A 98 prefix foreign tax identification number must first be acquired using the IRS Form SS4 and calling the 267-941-1099 number. Before completing Form SS4, understanding the rules to obtain the 98 number is very important. Section 21.7.13.3.2.7.1 5 what is this? May 16, 2018, titled Foreign Entities, Persons Not Required to File a U.S. Tax Return states. 1. Foreign corporations and individuals not engaged in the trade or business in the United States, or foreign partnerships, foreign trusts, and foreign estates that do not have gross income that is or is treated as effectively connected with the conduct of a trade business are not required to obtain an EIN unless they otherwise have United States source income, which the state liability was not fully satisfied by the withholding of tax at the source. However, a foreign entity may need an EIN to comply with IRS withholding regulations or to claim tax treaty benefits. In this case, the taxpayer should complete Form SS4 as shown below. Line 7B, provide a ITIN or SSN if appropriate, otherwise write NA. Line 10, check the compliance with IRS withholding regulation box, or in the case of claiming treaty benefits, check the other box and specify on the line for tax treaty purposes only Treasury regulation 1.1441-1 E47. See line 11 through 17. You're going to enter in A on all those lines. And then on line 2, you're going to establish these entities on the line O file. Okay? If the foreign entities or individual above receive a letter from the IRS soliciting the filing of a U.S. tax return, the foreign entity individual should respond to the letter immediately by stating that it has no requirement to file a U.S. tax return. Failure to respond to the IRS letter may result in a procedural assessment of tax by the IRS against the foreign entity. Number 4, if the application is received over the phone, ask the caller's name, social security number, address, date of birth, and position with the entity. If the caller does not have an SSN and therefore cannot be authenticated using CCC in null, the new EIN will still be disclosed to the caller as long as their position with the entity authorizes them to receive it. See IRM 11 or .3.2.4. Persons who may have access to returns and return information pursuant to IRC 6103E. The Internal Revenue Manual simply explained that those considered foreign to the United States could obtain their foreign tax identification number to remove all tax liability. Once the 98 number is obtained, the IRS will enter the foreign trust EIN on the O file, or the 0 file is basically what it is. The 0 file lists as an entity that never has to file not one return. Usually, the IRS sends a letter known as the CP 575 detailing all information given about the entity, such as its name, address, IEN, date of establishment, responsible party, and request tax return by a specific date. The trustee of the trust must respond stating that the entity has no requirement to do so under Title 26 U.S. Code 7701-30 and Title 26 U.S. Code 7701-31B. Before filling out Form SS4, the foreign national must determine 3 important key factors. First, the trust name should be entirely different from the name on the birth certificate or social security card. Depending on the nationality, research titles of nobility are given to families of notoriety within the applicant's nation. Second, a domestic address as the trust's mailing address and a foreign address from a foreign country as the principal place of business where the trust was established. Although the Republic of the United States of America is foreign to the United States, aka the District of Columbia, a foreign address from a foreign country is required because the IRS agent on the telephone are not trained to understand the difference between a republic address and a domestic federal address by way of the zip code. This is not an illegal action. A trust can decide when and where it began and what nation it is established under. It is a standard practice among corporations to have a principal address offshore, yet doing business within North America. For example, Experian PLC corporate headquarters is addressed Newenham House, Northern Cross, Malahide Road, Dublin 17, Ireland, but Experian is doing business in Canada and Costa Mesa, California. The third key factor and most important is a foreign trustee. The trust will need a person who has never had a USA birth certificate derived from one of the Internal Revenue District states, a social security card, a green card, legal permanent resident card, or any citizenship document issued by the U.S. Citizenship and Immigration Services. The identity and nationality of a trustee determine the overall jurisdiction the United States has over a trust. Note, if the applicant's primary language is American English, it is wise to select a foreign address in Amsterdam, Netherlands, such as a hotel or above or available office space, or any country where inhabitants have a native tongue similar to American English. Okay, y'all hearing this? Okay. If the applicant is indeed from another country, then by all means use the familiar accent of the native foreign country to validate the foreign address further. For this example, in completing Form SS4, Christopher Alexander Wellington is an American national born in the land of California, the territory of Los Angeles. He is employed with Target Inc., with plans of starting a small business in California. By birth, Mr. Wellington is foreign to the United States jurisdiction as a native Californian national seeking to enter the 0% tax bracket. The name of the foreign trust is Heinz Wolfgang Express Trust, whose trustee is Al-Hamid El Bin, a New South Wales Australian, with an established foreign address as Dam 9 1012 JS Amsterdam, Netherlands, and domestic address as 9999 Pepper Tree Boulevard, Street or Suite Q03, Los Angeles, CA 1119. Mr. Wellington will use a private mailbox from iPostal and not his residence. iPostal.com one is, or iPostal1.com is an excellent option to receive mail and no longer receive personal mail where he lays his head. Y'all taking notes? Remember, UCC 9-307. A debtor is located at their primary place of residence belonging to the District of Columbia. Okay? Let me check y'all out in the chat. I in tune and all the time. Whenever you drop, I love what you're doing. I need to find some material on child services. I mean, honestly, Neil, the apostate, this book that I'm reading, until you do what this book says, everything else is like a hit and miss. Okay. So it's better for you to, take heed to the readings and the words out of this book and get that out the way, and take the next couple of months to do this process that's being read here in this book, versus trying to get other remedies, and just try to take control of your estate, so that you won't have to keep going through certain things. That's my suggestion. One second, let me check on my grandbaby because I don't know if she's by herself or not. One moment. All right, Royals. As far as back to nail up the apostate now, I can help you with some things that you may be able to do, like putting in recording a deed, a baby deed on the at the county where you live, and potentially presenting that to um, your child services representative and seeing what happens with that. This can be overwhelming. We are going to have to use this book as instruction in the process. Absolutely. So please buy this book to help instruct and chart your process. Absolutely. Thank you, Miss Vicky. Hey, honey. All right, y'all. So let's get through this chapter and we're going to end for today, okay? Right. So continuing, all right, it says the below SS4 revised December 2019 instructions are as follows. Section 1, legal name of entity or individual for whom the EIN is being requested. So it's going to be for your trust, your express trust, Heinz Wolfgang Trust, okay? Then section 2, it says the trade name of business, if different. So you're going to put NA there. On section 3, you're going to say executor, administer, trustee, care of, or name of. So you're going to put in care of Ahmed El Bin, trustee. That's your trustee name, which is going to be your title of nobility name. Okay. Then for section 4A, you're going to put the mailing address of the domestic address. Okay. Section 4B, you're going to put city and state, zip code. Okay. Section 5A, you're going to put the street address, which is going to be the foreign address. Okay. So whether you choose the Amsterdam or whichever other one they suggested, or whichever one you find that is a English speaking language country. Okay, so section C, you're going to put the county and state where the principal business is located, and that'll be the county, the county where from section, the city and county or whatever from section 4B, okay? So then you're going to put section 7A is the name of the responsible party. That's going to be your title of nobility name, Ahmed El Bin. And then section 7B, SSN, ITIN, or IEN, you're going to put NA. Note, the foreign trustee was never issued a social security number. Suppose the applicant is still working on finding a foreign trustee and want to obtain their 98 number. In that case, the applicant can use themselves as the initial trustee in section 3 and the responsible party in section 7A. The applicant, Christopher Wellington, should use a new first and last name such as Christopher Oliver or Christopher L. and state they were never given a social security number. Okay, this was a reference to the twofold message by Yahshua when he stated in John 3:3, Yahusha answered and said to him, most assuredly, I say to you, unless one is born again, he cannot see the kingdom of God. Y'all hear that? Unless you're born again, you cannot see the kingdom of God. And that don't mean going and letting the pastor lay his hands with some oil on your forehead, okay? And confessing your sins. To be born again is to take on a new name that does not belong to the state, and also to be made new, walking in newness of life because of what Yahusha was going to do and as of today has already done. Yes, he did it. Isn't it fascinating that absolutely no one in the Bible has a last name? Yes, it is. What new Bibles have done was merge titles of nobility, such as Daniel, Gabriel, Michael, Israel, Meshach, Zedek, or Mary of Magdalene. Wow. Section 8A is the application for a limited liability company, LLC, or a foreign equivalent. You're going to say no. Section 8B, you're going to skip. Section 8C, you're going to skip. Section 9A, type of entity is going to be trust, TIN of grantor, express trust. Okay. Section 9B, you're going to skip. Section 10, your reason for applying is going to be other with specify. You're going to specify W8BEN purposes only. Okay. Section 2, date business started or acquired, month, day, and year. Select a day 3 months before the current day. Section 12, closing month of accounting year. Okay. December 21st, so it'll be 2022 in our case. Note, always the last month of the year and the current year end of the application, okay? Section 13, skip all the way to 15, you're going to skip. Section 16, check one box that best describes the principal activity of your business. You're going to put other, unincorporated church association. Note, why an unincorporated church association trust law is derived from biblical treaties and the government follows the rules and regulations of the Bible. A trust requires a minimum of 2 persons, a settlor and a trustee, to fulfill 3 positions: a settlor, a trustee, and a beneficiary, just as the Bible states. That's the Trinity. God is the true God, the Father, the Son, and the Holy Spirit. Man comprises 3 parts: bada boom, bada bing, flesh, mind, or soul, and spirit. In like manner, the government has a minimum of 2 persons, the president and the vice president, with 3 branches as legislative, executive, and judicial. The Bible states that man is the church, and wherever a man goes or whatever activity a man is engaged in, God will be in the midst. Bada boom, bada bing. Tell y'all pastors that. Every man is a church, and therefore every man is an unincorporated church association who occasionally enters into partnership. The unincorporated church association is automatically tax exempt as described under Title 26 U.S. Code 508C1A and completely distinguishable from a religious organization, Title 26 U.S. Code 501C3, which can be taxed if the religious organization does not adhere to the rules of subsection 501C3. The Bible is surprisingly one big trust book. Yep. The church is tax exempt, avoiding usury, also known as interest, stated throughout the Old Testament, which the government has codified as law under Public Law 280, October 4th, 1982. 96 Stat 1211. Continuing with the 498 application, Section 17, we're going to skip. Section 18 has the applicant entity shown on line 1 ever applied for and received an EIN. You're going to say no. That's it. Congratulations. If the applicant provided the above information to the IRS agent over the phone, the applicant should have a 98 prefix tax identification number. As previously mentioned, the IRS may send the applicant its CP 575 letter confirming all of the provided information. May state the following. Based on information received from you or your representative, you must file the following forms: 1041, 1040, 1065 by the dates shown. Regardless of receiving this letter, the trustee should send some type of statement to the IRS to altogether confirm its lack of tax return liability. The statement provided below, using the example used in the SS4 instructions, will guarantee a confirmed statement from the IRS that the trust is on the zero file list. Note, the following abbreviations are defined U/D as under declaration, TTE as trustee, or TR as trust. Month, day, year, Ahmed L. Bean, TTE, or Christopher Olive, or L, TTE. You under declaration of trust, Heinz Wolfgang Express Trust, care of your domestic address. Okay. Attention Department of Treasury, Internal Revenue Service, Cincinnati, Ohio, 44599 through 00, blah, 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 blah. Regarding IRS Form SS4 application, C575, IEN number, and you put your 98 number there. I, Ahmed L. Bin, trustee of the Heinz Wolfgang Express Trust, on behalf of the trust beneficiaries, wish to provide the Internal Revenue Service with additional information regarding the trust. The trust is aware that the Internal Revenue Service may request an entity's IRS Forms 1040, 1041, or 1065 by a determined date. Take judicial notice that the Heinz Wolfgang Express Trust is a foreign trust established in Amsterdam and was assigned the EIN number 98 blank for tax classification purposes. The foreign entity and its representatives have no requirement to file any U.S. tax return according to IRM 27.7.13.3.2.7.1, 0516 2018. The foreign trust and its representatives are not United States persons per Title 26 U.S. Code 770130 and not a domestic trust under the supervision and jurisdiction of any court within the United States District of Columbia per 26 U.S. Code 770131B. Please be advised right now that submitting an EIN application for W-8BN purposes only, as stated on the attached IRS Form SS4. Should you have any questions or concerns, you may write to our attention via the address listed above. Attached IRS Revenue Service Form. Thank you for your prompt attention to this matter. Signed, Ahmed L. Bin, TTE, or Christopher Olive, or L, TTE. Office with your number, okay? It is best to include a copy of the exact information on the IRS Form SS4 given to the IRS agent over the telephone. The IRS may take up to 6 months to process your statement, but once the IRS has accepted your letter, a correspondence from them should state, "Dear taxpayer, thank you for the inquiry dated with the month, day, and year. Our records show you are no longer required to file such forms. The next step is to proceed with a two-step process in converting the employee's public insurance bond, i.e. SSN-ITIN, into a foreign estate. It will first be classified as a domestic estate, which will further be converted into a foreign estate. To accomplish this, the same SSN-4 is needed, except this time it will be done online by searching Apply for EIN online and select www.irs.gov, apply for an employee identification number, EIN online. The applicant can only be completed Monday to Friday during the operating hours of 7 a.m. to 10 p.m. Eastern Standard Time. The only thing required to complete this process is the applicant's employee public insurance bond, SSN-ITIN, uncertificated security. The process is as follows. After selecting Begin Application Now, the first set of options given is the entity selection. The correct entity to choose is the estate. People are led to believe the estate is only chosen upon a loved one's death in an attempt to settle their financial affairs. According to the IRS, there are two kinds of taxes owed by an estate. First, on the transfer of assets from the descendant to their beneficiaries and heirs, the estate tax. And second, on income generated by assets of the descendant's estate, the income tax. When someone passes away, their assets become the property of their estate. All income generated by the assets is part of the estate and may cause the filing of an estate tax return. The descendant's estate, or the decedent's estate, should I say, may generate assets, including but not limited to savings accounts, CDs, stocks, bonds, mutual funds, and rental property. IRS Form 1041, U.S. income tax return for estates and trusts, is required if the estate generates more than 600 in annual gross income. Interestingly, the estate number can be used for much more than a death benefit. It is a 9-digit number like any SSN, ITIN, or business IEN, also known as a credit profile number. It can be used to access high limits of corporate credit. This is a necessary skill to learn as the Social Security number and ITIN are surrendered and abandoned going forward, except if the applicant wishes to finance real estate and obtain a mortgage to convey the property to a trust. It should be noted that an inactive SSN becomes on par with a dissolved corporation after 3 years. To continue to use the public insurance bond, SSN, ITIN in the form of credit cards, cell phone contracts, auto loans, auto insurance, all insurance accounts, or bank accounts, knowing that nationals are not U.S. citizens would be counterproductive, accepting the United States benefits and privileges. Therefore, it is recommended to use the foreign estate credit profile as a replacement to the SSN ITIN and in the same name, and only maintain installment credit accounts in the SSN ITIN credit profile rather than revolving accounts. Okay? For the sole purpose of obtaining a mortgage, which is optional. The trust will protect the asset and the applicant's commercial status to remain national but not a U.S. citizen. In continuing with the online estate application, after selecting an estate, the next page requires the applicant to confirm this selection, and the IRS provides a little more information as to what an estate is. One key component that the IRS points out is that the estate consists of the deceased person's real and personal property. Remember, the United States and the IRS are referring to the 14th Amendment fictitious entity previously mentioned during the explanation of the Cestui Que Vie Act of 1666. This entity is a corpse, a corporation only on paper. The personal property that the applicant is taking control of is the corporate public insurance bond backed by the certificate of birth or birth. To verify one of the estate's security accounts, perform a Google search, Treasury Direct Calculator, and select treasurydirect.gov BC, /BC/BSBC price dot. Inside of the savings bond calculator under series, select EE bond. Under denomination, select 10,000. Under bond serial number, enter the birth certificate number or driver's license, passport number, or SSN ITIN. And lastly, under issue date, enter the correct issue date and year of the security that you choose to look up this information. So one of these, whether you're using the driver's license, this number on the certificate, so that it has an issue date on there, you want to use that. The results will populate the bond's interest and value, and there are many bonds in the name on the birth certificate. The application's next page requires the applicant to provide information about the deceased corporation to the applicant's first, middle, and last name, including any suffix that matches the Social Security card and birth certificate. It may be shocking to know that the estate contains trust fund money logged into accounts where the registrar first created the 14th Amendment person. One moment, you guys. Jeez. Okay. The application's next page requires the applicant to provide information about the deceased corporation, the applicant's first, middle, and last name, including any suffix that matches the Social Security card. Blah, blah, blah. Okay, didn't we read this already? Maybe not. Okay. And birth certificate. It may be shocking to know that the estate contains trust funds, money logged into accounts where the registrar first created the 14th Amendment person. The funds are held within the county CAFR Comprehensive Annual Financial Report and the Depository Trust and Clearing Corporation. Many corporations worldwide use the labor of U.S. citizens and collateral for the corporation's taxes due and liabilities. For example, many Americans are familiar with the $13.4 billion 2008 General Motors bailouts, causing all taxpayers to pay General Motors debt. This is why all U.S. citizens and legacy corporations are listed as human capital on the NASDAQ. Only corporations can settle another corporation's debt, and the 14th Amendment fictitious person is doing just that. I'm sorry, man. I keep getting distracted. To see evidence of the many corporations doing business in all alleged U.S. citizens' name, simply go to www.gmeiutility.org. Click on the search icon and enter the Social Security number with dashes. All of the companies and trust companies revealed are doing business in the name of the United States fictitious corporate name and holding them accountable for all debts, liabilities, and losses. To remove oneself from this immense level of fraud, claiming the estate is paramount and must be completed with the 98 foreign tax identification number. Owning the estate's assets. A foreign trust is similar to a holding company or lis pendens, otherwise known as a notice of pendency, alerting the world that the trust has a lien via the non-UCC filing on the estate. The applicant should enter their name as the EIN application in all capital letter format. Christopher in the first name box, Alexander, family of in the middle name box, and Wellington in the last name. Select junior, senior, etc. if applicable. And lastly, enter the applicant's SSN number. Okay. So let's read that again. The applicant should enter in their name in the EIN application, the all capital letter format. So Christopher will be the first name box. Alexander, family of, will be in the middle name box, and Wellington will be in the last name box. Okay. Select junior, senior, etc. if applicable, and lastly enter the applicant's SSN, ITIN. Okay. The following page requires information about the executor, administrator, personal representative. If the principal person is processing this application, then the executor is the proper selection. In the upper and lowercase format, enter Christopher. in the first name box, Alexander in the middle name box, and Wellington in the last name box, okay? Enter the SSN, ITIN again, and select executor as the fiduciary title. The last question on this page must confirm the identity of the one completing this application. Again, the principal person is completing this application. Then there is no third party or power of attorney to be listed. Therefore, the person selection applies. I am the executor, administrator, or personal representative of this estate. On the contrary, if another person, such as a third party, delegated executor, their information, including SSN, will be required. The next page asks for the applicant to provide a valid mailing address according to the UCC 9-307B debtor's location. 2. A debtor is an organization and has only one place of business located at its place of business. Therefore, it is necessary to use a private mailing address that is separate from where the principal applicant rests regularly and cannot be a United States postal mailbox. The correct address should be the origin of the 14th Amendment fictitious entity created by the registrar at the county office or the county courthouse headquarters. Mr. Wellington was born in Los Angeles, California, per the Los Angeles County government. The registered county recorder, county clerk office is located at 12400 Imperial Highway, Norwalk, California 90650. And the Los Angeles County Superior Court is 3 in Hill Street, RM204, Los Angeles County. Since Mr. Wellington provided the county courthouse address as the debtor residence on the UCC 9 filing, the registered address should suffice on the estate application. The birth certificate was the first security created to bring about the ens legis. On the next page, the applicant must provide information regarding the origins of where the estate is probated. Probate court always deals with equity matters, sometimes referred to as Chancery Court or the King's Court. It allows the government to determine what is their property and what is not. The applicant's trust funds and or inherit held within probate, and the county courts have the records of what assets are descendable. This is why upon death and in the absence of a will or trust, the local county assumes all of the decedent's property, further administering the estate assets in their 14th Amendment trust. Simply provide the county of the applicant's birthplace in the first box in all capital letter format. Simply provide the county of the applicant's birthplace in the first box in all capital letter format. Mr. Wellington would provide Los Angeles, the county where the estate is probated, California, state territory where the estate is probated, August 1999, date estate created, funded, or probated. Note, the year cannot be more than 25 years from the current year. Why? As previously stated, the 14th Amendment fictitious entity was created within the 14th Amendment trust itself, such as a corporate trust, which is perpetual and is governed under statutes and codes. Any trust that provides a specific amount of years, up to 20 to 25, is automatically considered an express trust and is governed under equity law. The IRS is seeking to find out if the estate is under equity law or statutory law. Mr. Wellington is 22 years old, born in 1999, and the current year is 2021. If the applicant is older than 25 years of age, take the difference of 24 years from the current year, which will be the maximum date allowed, and December as the closing month of the accounting year. The application's following page asks if the applicant will have or expect any employees in the next 12 months. At this time, the correct answer is no. However, the estate could hire employees in the future. As the application comes to an end, the applicant can receive an EIN confirmation letter online or via the mail. Selecting online is fastest and most efficient option. The final page allows the applicant to verify and confirm everything is correct. The applicant should see the legal name as Christopher Alexander, Family of Wellington Estate. This is the correct format. Upon accepting the estate's confirmation, the applicant should receive the first page of a domestic estate number. It is wise to save the PDF IRS Form CP 575 and make copies for safekeeping. Now that the SSN-ITIN has its estate, the applicant should have a 9-digit number encoded as a domestic estate. The second part of the two-step process is converting the domestic estate into a foreign estate by way of IRS Form 8832, Entity Classification Election. Filing the two-page form is as follows. Name of eligible entity making election, Christopher Alexander, Family of Wellington Estate. Employer identification number, whatever that will be. Okay. Number, street, and room or suite number if a P.O. box. See instructions. 12400 Imperial Highway, register address. Okay. City or town, state, and zip code. Okay. So that's of the registrar address. Okay. Section 1. Type of election, you're going to select A, initial, it says A, initial classification by a newly formed entity. You're going to skip lines 2A and 2B and go to line 3. Selection 3, does the eligible entity have more than one owner? You're going to say no. You can elect to be classified as an association, taxable as a corporation, or disregarded as a separate entity. So go to line 4. Section 4 is if the eligible entity has only one owner, provide the following information: name of the owner. That's the Heinz Wolfgang Express Trust. Okay. Identifying number of owner, which is going to be your 98 number. Then you're going to do section 5. If the eligible entity is owned by one or more affiliated corporations that filed a consolidation return, provide the name, but that you're going to put NA for A and B, okay, you guys? Section 6, type of entity. F, a foreign eligible entity with a single owner electing to be disregarded as a separate entity, okay? That's what you'll select. For section 7, if the eligible entity is created or organized in a foreign jurisdiction, provide the foreign country or organization. If you chose Amsterdam, it'll be Amsterdam. Section 8, election is to be effective beginning the month and date, which will be the date you're filling that document out. Okay. Section 9, you're going to put the name and title of contact person who's going to be the trustee. It says whom the IRS may call for information. It'll be your title of nobility name, okay? Ahmed L. Bean, TTE. Section 10, you're going to contact person's telephone number, office, okay? Consent, statement, and signatures. Provide 2 signatures, 2 dates, and titles of each signature. The first should be the executor's print name, today's date, and their executor and signature. The second should be the trustee of the foreign trust, which is going to be the Ahmed L. Ben or Christopher Oliver or L. print name, today's date, their title as beneficial owner, and then put the signature. The completion of IRS Form 8832 finalizes the conversion of the SSN ITIN from a domestic to a foreign trust. The estate is now under the jurisdiction of the 98 Foreign Express Trust. Depending on the state the applicant is filing from will determine whether IRS Form 8832 should be sent to Kansas City, Missouri, or Ogden, Utah. See the instructions page provided in the 8832 form. The IRS may reply with a correspondence stating that the applicant's arguments were found frivolous. If such a letter is received, don't panic. The applicant did nothing wrong. It is merely because the IRS has specific quota of how many foreign 98 tax identifications numbers can be issued in 3 months, and how many estate reclassifications can be allowed under a foreign jurisdiction. A frivolous correspondence is just the Internal Revenue Service's funny way of saying they can't complete the applicant's request at the moment. Simply resubmit the IRS Form 8832 precisely as before, and second attempt is certainly a guarantee. The approval letter will state important information about your Form 8832. We approved your Form 8832 entity classification election. We have provided your election as a foreign eligible entity with a second owner to be described as a separate entity. The effective date of this election is, it'll show you the month, day, and year. The foreign trust will own all wages earned by the employee's estate and all earnings produced by any businesses in the jurisdiction of the foreign trust. Since the trust is on the zero file list, every other entity under its classification is also on the zero file list. This is how wealthy families preserve their wealth for generations. The United States debt is up to 300% from 20.4 trillion in the year 2000 to 60.2 trillion in the year 2009, according to David Walker, the former U.S. Comptroller General who served under the 3 U.S. presidents. The national debt is the United States obligation, not the people, and it can be avoided. However, the people do play a part in the debt's existence. The process of tax avoidance is lawful, but tax evasion is illegal. Some tax code practitioners use other corporations, partnerships, or LLCs as holding companies for other businesses to preserve wealth or save on the tax amount of taxes due. However, this method will promote slight savings, but taxes are still due anywhere from 15 to 20% per Internal Revenue Code 541 to 547. In the recent example, the employee Christopher Alexander Wellington is employed with Target Inc. in California. He has completed the estate conversion under his trust name, the Heinz Wolfgang Express Trust, which both entities are now in the zero tax bracket. Mr. Wellington can now update his tax reporting information in one of the two ways. The first option is by remaining an employee with Target Inc. and filing the 2020 IRS Form W-4 with his SSN or ITIN manually write exempt in Step 4, Section C, to claim federal tax exemption from withholding, and also manually write exempt in Section 3 of California's 2020 employee withholding allowance certificate regarding state tax exemption. Social Security and Medicare taxes will continue to be withdrawn from Mr. Wellington's paycheck until the Human Resources Department at Target Inc. receives a statement from the trustee of the 98 Foreign Trust. This statement is the IRS Form 4029, application for exemption from Social Security and Medicare taxes, and waiver of benefits. This exemption is only granted if the IRS finalizes and returns a copy to Mr. Wellington approved to forward his employer. So it says this exemption is only granted if the IRS finalizes and returns a copy to Mr. Wellington approved to forward to his employer. Okay. Part 1 of the application requires the applicant's name, social security number, address, and date of birth. Box 5, check do not send me my social security statement. This form works in correlation to the 98 Foreign Trust being described as a religious group. The applicant would complete the following sentence in part 1 as I certify that I am and continuously have been a member of the Hines Wolfgang Express Trust, name of religious group, Treaty of Marrakesh 10 12 JS Amsterdam, Netherlands, foreign district or congregation address, such month, day, year, and as a follower of the established teachings of the group, I am consciously opposed to accepting benefits of any private or public insurance that may that makes payments in the event of death, disability, old age, and or retirement, or makes payments for the cost of medical care or provides services for medical care. Public insurance includes any insurance system established by the Social Security Act. Part 2 of the application must be completed by the trustee or the authorized representative hired by the trustee to certify the above statements. Mr. Wellington must make 2 copies of the original IRS Form 429 and mail all 3 copies, including a W-9 with the 98 foreign tax identification number, the recorded declaration of express trust, which provides information about the foreign sole trustee as the holder of all estate assets to Social Security Administration. Social Security Records Branch. Attention, religious exemption unit, P.O. Box 7, Boyers, Pennsylvania, 16020. Information regarding the Express Trust will be provided in the upcoming chapters. Once the SSA department approves their portion of the application, they will forward the necessary copies to the IRS for final approval, to which Mr. Wellington will receive proper notice to deliver to his employer. All Medicare and Social Security taxes will cease from this point on. Treaty law is the supreme law of the land. The Express Trust operates fully in conjunction with the several treaties connected in the United States dating back to the corporation's beginning. The updated W4 and DE4 and IRS Form 429 are only necessary if the employer refuses to accept to pay Mr. Wellington earnings as an independent contractor using IRS Form W-9 with the foreign estate EIN. Most employers will not accept the W-9 due to the ongoing court battles of determination and employees' finalized definition as a contractor. W-4 forms have been the only non-belligerent method of the hiring process in the United States. Furthermore, there will be no need for Mr. Wellington to file a tax return at the end of the year since he has kept all his earnings throughout the year. His employer will provide him the IRS Form W-2 to file his taxes. Instead, Mr. Wellington will discharge any tax bill consisting of federal and state obligations using the Express Trust unless Mr. Wellington wishes to utilize the Foreign Express Trust and claim the entire annual debit, credit, and cash transactions as business deductions to receive every dollar back as a tax refund. The foreign trust can claim all of its expenses as deductions and losses, in a sense, receive its income in the form of a tax return. Second option Mr. Wellington can do is update his work status from employee to a contractor with Target. Filing a W-4 is optional. And as mentioned before, providing a W-9 as an independent contractor with the foreign estate EIN will remove all federal, state, Social Security, Medicare, and other withholdings from each paycheck. If the employer is willing, Mr. Wellington would need to complete the W-9 precisely, which is explained in the upcoming chapters. However, this is the only form Mr. Wellington would need to work as a contractor completely, and he would have the chance to have the Foreign Express Trust file taxes at the end of the year to receive his annual income as a second occurrence. Boom. In the meantime, Mr. Wellington could or would like to start a pet grooming business in California. Most advisors would advise him to move to a more tax-friendly state like Nevada due to the high annual state tax of $800 in California. The 800 tax is mandatory no matter if the business has earned 1 cent. It is a privileged tax to do business in California. However, most advisors do not know Mr. Wellington is on the zero file list, and all he has to do is exercise his valid determination letters with the state. It is necessary to determine what type of entity would best serve its nature to begin a California business. Any business entity selected, such as a corporation, limited liability, limited partnership, general partnership, limited liability partnership, or sole proprietorship, will need a business employer identification number. The objective is to generate as much money as possible with any business plan and reduce the amount of taxes owed to 0% from its inception by reclassifying the entity to a foreign entity under the jurisdiction of the 98 foreign trusts. For example, Mr. Wellington will use a general partnership for the dog grooming business, which will consist of two partners, his fiance as co-partner and himself as the general partner. According to California Corporations Code, Title 3, Chapter 1, Section 18035, unincorporated association means an unincorporated group of two more persons joined by mutual consent for a common lawful purpose, whether organized for profit or not. The definition of an unincorporated association has similarity to a trust, requiring a minimum of two persons, and under common law, which is reminiscent of express trust, common law finds its jurisdiction heard only in a court of equity. Mr. Wellington and his fiancee have decided to call the name of their business SoCal Pet Spa and have confirmed the availability of the business name via the Secretary of State website and the County Recorder's Clerk of Office by filing a fictitious business name statement providing its principal place of business address. A general partnership EIN was obtained from the IRS EIN online process, which was then converted to a foreign entity using IRS Form 8832. The approval of the Form 8832 allowed Mr. Wellington to further submit a correspondence letter to the IRS stating that the general partnership is not obligated to file any tax return. In response, the IRS provided an IRS determination letter stating that their entity is not required to file a 1040 or 1041 or 1065 tax return. The partners will open a general partnership bank account by providing a copy of a bilateral partnership agreement, fictitious business name, statement, and their IRS CP 575 EIN confirmation. The bank will also require the partners to file their short form general partnership agreement with the California Secretary of State office by filing Form GP1, Statement of Partnership Authority. The information to the GP1 can be derived from the bilateral partnership agreement within common law jurisdiction provided on the next page. General Partnership Agreement. Monday day year by and between the following. So it says this partnership agreement or agreement is made on Monday day year by and between the following, who shall be referred to in this agreement as partners: Wellington Christopher Alexander with his address there. Okay, and then Johnson Tiffany Burton with her address there, okay? Yeah, damn it. Okay, Article 1, overview. Type of business. 1.1. The partners shall associate to form a general partnership for the purpose of investment securities and render services to the general communities. To several communities, and shall have the power to do all lawful acts to further the partnership business as an unincorporated church organization. Partnership name. The partnership name shall be SoCal Pet Spa General Partnership DTD, the date it started under the laws of California State. Partnership term. The partnership shall commence on the day that this agreement is executed and shall continue until dissolved by agreement of the partners or terminated under provisions of the agreement. Place of business. 1.4. The partnership's principal place of business shall at 9876 Central Avenue, Suite 537, Santa Monica, California, Republic, near 19404. The partnership shall operate in other places of business agreed upon the partners. Purpose. 1.5. The nature of the general partnership is hereby declared to exercise its religious instructions and beliefs. Title to USC Code 200 BBA, and C. Holding consultations, offering goods, publishing, promoting, filing statements, procuring applications, recording invoices, in the furtherance of education, science, transportation, and giving to the public within various incorporated counties and territories of California State, honoring the covenant of God with all of mankind, Act 20.35, Hebrew 13.16, etc. Each partner shall be known as a church and exercise their inalienable God-given right protected by the 1849 California State Constitution, Article 1, Declaration of Rights, Section 4, and per the United States of America Constitution, Full Faith and Credit Clause, the 1877 Georgia Constitution, Article 7, Section 2, Paragraph 2, shall apply in uniform to the nature of the general partnership in California State. Article 2, Capital and Accounting. Initial capital. 2.1. The partnership's initial capital shall be $100.00 USD. Each partner shall contribute the initial capital by depositing the following amounts in the partnership business account at any National Association credit union or on or after this day of, or any Federal Reserve Bank. Wellington Christopher Alexander, $50.00 named contribution. And then just Johnson Tiffany Burton, $50.00 named contribution. Capital withdrawals. No partner, known as co-partner, shall withdraw any portion of the partnership capital without the other partner, general partner, express written consent. Profits and losses. The partners shall share equally in partnership net profits and share bare partner losses equally. Books of account 2.4. Okay. Partnership books of accounts shall be accurately kept and shall include records of all partnership income, expenses, assets, and liabilities. Each partner shall have the right to inspect the partnership books at any time. All right, let me plug my computer up, guys. Okay. Fiscal year 2.5. The partnership's fiscal year shall end on December 31st each year. Accounting 2.6. Complete accounting of the partnership affairs shall be provided at end of quarter and provided to each partner within 15 after quarter end. At the time of each accounting, the net profits of the partnership shall be distributed to the partners. Net profits shall be profit as designed by generally accepted accounting standards, less required working capital as determined by the partners. Article 3, Management. Time devoted to partnership. 3.1. Each partner shall devote undivided time to and use the utmost skill in partnership business, management, and authority. 3.2. Each partner shall have an equal right in the management of the partnership. Each partner shall have the authority to bind the partnership in making contracts and incurring obligations in the partnership name or on its credit. No partner, however, shall incur obligations in the partnership name or on its credits exceeding $100,000 USD, $100,000 without the partner's express written consent. Any obligation incurred in violation of the provision shall be charged to and collected from the partner who incurred the obligation. Article 4. Statement of Partnership. 4.1. Concurrent with the execution of this agreement, the partners are fully aware and acknowledgeable the rules and laws that this general partnership does not require any filings or recordings of a statement of certificate of partnership authority with the California Secretary of State of Office pursuant to California Code, Corporations Code, Title II, Partnership, Article 1, General Provisions, Section 16105A, with a respect to partnership property located in or transactions that occur in that state. Article 5, Withdrawal and purchase of partnership interests. Withdrawal of partner. 5.1. Upon 45-day written notice of intent to the other partners, a partner may disassociate from the partnership by withdrawing as partner. Notice shall be United States mail certified first class postage prepaid via certificate of service addressed to a partner at the partner's address set forth in the agreement or to such other place as may be specified in a notice given to pursuant to this paragraph as the address for a service of notice on that partner. Option to purchase disassociated interests. Disassociation by a partner due to the death, withdrawal, or other act, the remaining partner may continue the partnership business by purchasing the outgoing partner's interest in partnership assets and goodwill. The remaining partners shall have the option to purchase the disassociated partner's interest by paying to the outgoing partner or the appropriate personnel representative the value of the disassociated partner's interest as determined by an outside appraiser. If the remaining partners do not exercise this opinion, the partnership should be dissolved. Article 6, Miscellaneous Provision, Consents and Agreements. 6.1. All consent and agreement provided for or permitted by this agreement shall be in writing. Designed copies of all consents and agreements pertaining to partnership shall be kept with the partnership books. Notice 6.2. Any notice to be given or served upon the partnership or any party hereto in connection with this agreement must be in writing at the address shown in Article 1, Section 1.4. Any party may designate any other address in substitution of the foregoing address by giving 5 days written notice to all members. Governing law. This agreement, 6.3, shall be governed by the California Uniform Partnership Act of 1994 as amended, and shall in all respect by a contract under the 1849 California Constitution and other constitutions of the several states and the Union pursuant to the 1789 Constitution of the United States of America, Article 4, Section 1, Full Faith and Credit Clause, Article 1, Section 10, Clause 1, Contract Clause entitled Title 26 U.S. Code 508 C1A. Attorney fees. 6.4. As between the parties to this agreement, the prevailing party in any dispute arising from or relating to this agreement shall be awarded costs and attorney fees, whether or not the matter is resolved by trial or appeal. Sole agreement. 6.5. This instrument contains the partner's sole agreement relating to the partnership. It correctly sets out the partner's rights and obligations. Any prior agreement, promises, negotiations, or representations not expressly set forth in this instrument have no force or effect. Certificate of acknowledgement. We, the undersigned, declare or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. 28 U.S.C. Code and 1746 1, and was signed as a free and voluntary act and deed for the issues and purposes stated therein, executed in the county of Los Angeles, California, this day. Wellington Christopher, with the date of birth and signature, general partner, and the other parties, date of birth and signature, blah, blah, blah. The above is a complete general partnership agreement that covers every aspect of any business plan. Any business requiring more than one employee and multiple managers, then an LLC or corporation should be established. There are several examples available on the internet as a rule of thumb to draft articles of incorporation or articles of organization to be filed with the Secretary of State in the proper commerce state. The most important language to include in any business structure is found in Section 6.3 regarding the governing law. By successful reclassifying the entity via IRS Form 8832, the operating agreement must state its jurisdiction because a separate contract from the United States, being a separate contract from the United States and does not seek any tax exempt benefit or protection from the United States, such as Title 26 501c3. Instead, it operates as a church under Title 26 508c1a, according to the California Secretary of State website. A California GP must have two or more persons engaged in a business for profit. Okay. Except as otherwise provided by law, all partners are liable jointly and severally for all and severely for all obligations of the partnership unless agreed by the claimant. Profits are taxed as personal income for the partners. To register a GP at the state level, a Statement of Partnership Authority, Form GP1, must be filed with California Secretary of State Office. Registering a GP at the state level is optional. Form GP1 is optional because a general partnership has the same characteristics of a trust, which is a private contract with no state of jurisdiction can control and therefore does not need the permission of any entity to exist. However, it should be filed for two reasons. First, opening a bank account for deposits and withdrawals for the nature of business and solely obtaining a California state entity file number or number to file a specific form with the California Secretary of State office regarding state taxes. This form is known as California Form 3500A, Submission of Exemption Request. The objective is to inform the Secretary of State that the business is not required to file any tax return to the Franchise Tax Board per the Internal Revenue Service. Remember, due to California ceding its jurisdiction over to the District of Columbia, and the state will heed the IRS direction. If the IRS determination letter states that the entity is not obligated to file a federal tax return, then the state will determine there is no obligation to pay state taxes. A California business can obtain exemptions based on Internal Revenue Code Sections 501c3, 501c4, 501c5, 501c6, 501c7, or 501c9, or federal determination letter. The federal letter is precisely what Mr. Wellington has obtained from his efforts of adequately setting up his pet grooming business as one that is foreign to the United States, because it is a guide to complete. Below is a guide to complete 3500A form. Enclosed, a copy of the Federal Determination Letter, Organization Information, California Corporate Number, California Secretary of State File Number, will be the FEIN, your Federal Employer Identification Number, which is going to be that 85 number that you obtained. Name of organization as shown in the organization's creating document, Social Pet Spa General Partnership, with the website, if any, the street address of the business, telephone number of the business, if any, fax number, representative information, name of representative is going to be Christopher Alexander Willington. And then you'll list such email addresses and representative's mailing address, which is going to be whatever the representative's mailing address is, okay? So, city. So as you can see here, you're putting those particular brackets where you see them for city and brackets for the zip code. That just basically means near. Taking it out of the jurisdiction of the zip code laws, whatever. Part 1, entity information. As a franchise tax board, FTB previously revoked the entity's tax exempt status. No is what you're going to select. Is the entity a trust? You're going to say no. When did the organization establish, incorporate, organize, or conduct business in California? You put the date that the entity was established. Provide gross receipts for the current year, and 3, immediately preceding taxable years in existence. Gross receipts are defined as the organization's total number or total amounts from all sources during its annual account period without subtracting any cost or expenses. If the organization has been in existence for less than 1 year, provide the projected amount of gross receipts for the entire year. List the accounting period beginning from the accounting period. Example, month, date, year, and then put 2. Projected gross annual. You put the number there. Part 2, group exemption. Is the parent organization applying for a group exemption? You'll put no. It says, is a subordinate unit applying for a tax exemption status using a parent's IRS group termination letter? You say yes. No, include a copy of the 98 determination letter from the IRS stating that it is not required to file returns or federal taxes, and provide a copy of the IRS letter corresponding the IRS Form 8832, which states or should state that the general partnership has been approved as a foreign entity classification. Mail Form FTB 3500 and a copy of the federal determination letters to the following address, you guys. Exempt organizations unit, okay? The date and birth, all right. General partner, put his title. Exemption based on IRC 501 section C3 federal determination letter. Church, the application is complete, providing a restricted endorsement, 28 USC 1746 1. In parts 2, signature section removes the assumption and jurisdiction of agreeing to penalties of perjury under the state of California statutory law, which is the District of Columbia. That's it. No more 800 minimum tax state tax obligation in the state of California or any tax due to the business amount earned. Mr. Wellington and his soon-to-be bride have successfully created a tax-free business from its inception. The Secretary of State will provide an approval letter of the FTB 3500A form, which is guaranteed. In the meantime, the two partners can open a business bank account with a bank or credit union that offers business accounts. The required documentation needed is two forms of ID, Social Security card or ITIN, letter from each partner, general partnerships agreement signed by both. California Secretary of State's Statement of Partnership Authority Form GP1 showing the California file number, the IRS CP 575 showing the federal employer identification number, and $100 initial deposit. The bank will make copies of the provided documentation and use the FPIN to open the account. Mr. Wellington is now on his way to generating the wealth that he deserves, transacting commerce as a native Californian national, not a citizen of the United States. Even Mr. Wellington decides to put the business on hold and continue working with Target Inc. or any employer. He is earning money with his Social Security number as a foreign estate and the IRS system, not subject to 37% withholdings. The foreign estate avoids being the United States jurisdiction or in the United States jurisdiction by having any federal state taxes withheld from his earnings, which is not effectively connected with the conduct of a trade or business within the U.S. His general partnership business is also not effectively connected with the conduct of a trade or business within the U.S. because it is operating in a foreign country to the U.S. known as the Republic of California. Every state has a similar process with similar forms to accept the Internal Revenue Service's determination letters. The only procedure left to accomplish is to draft the irrevocable foreign instrument known as the Heinz Wolfgang Express Trust and register the trust in probate court or the county recorder's office, which will be explained thoroughly in the upcoming chapters. Whew. That definitely was a long read, but we've learned so much, you guys. Absolutely. Greetings. Hey, Hair Slayer for Justice. Peace and love to you. I'm glad you all stuck around. This can be overwhelming. I read that. I'm following the book on Scribd until I am able to purchase it. Don't forget to use this book as an instruction manual to chart your process. Absolutely, Mother Vicky, you're absolutely right. So, guys, that concludes today's reading. I am so thankful that you all chilled with me for the last 3 hours and got this knowledge. I'm super hungry now and worked up an appetite and a thirst. Most definitely. So I'm gonna go get me probably some good old spaghetti that my daughter made. And hold on one second. Okay, so I appreciate you all. And again, if you guys would love to make a donation, just reach out to me or check out the description area of the video. If you want to get any of the books that I recommend, any of the books that I've read on my channel, check out the link to my Amazon affiliation page and any proceeds of the sales that are generated from my link as an affiliate with Amazon. I will get a percentage of that sale. So that can be considered as a donation as well and will help out you guys. This is definitely valuable information. If you want to get it free. We've been going around in circles getting thrown here into and told to do this and told to do that, and for such a long time, you guys, for such a long time. Many people have been learning this information for about 10 to 15 years. I mean, I on and off have been doing this and learning this since like 2004, 2005 myself. So that's almost 20 years. So with that being said, it's like it is definitely time to get what belongs to us, you guys. It is time to get what belongs to us. And we got the blueprint right here. Shouldn't be no other questions or concerns about it. We pretty much know who we are at this point. Um, I got to get with one of my members. We'll probably be doing genealogies in my community in the class on Thursday, because this Thursday we got, this Tuesday we have a special guest that's coming to do a presentation in class. So if you're not a part of Freedom Writers community, y'all want to reach out to me, send me an email so you can go through the screening process and fill out the NDA so you can get in, so you don't miss what we're doing over there in Freedom Writers over in the Telegram chat and on Zoom. Also, a perk that comes with being within Freedom Writers is your access to my lovely friend, Mother Mia Shay, her Grow, Show, and Know class. You know, she's teaching us some amazing things on how to grow foods, how to sprout vegetables, and within 7 days, within 5 to 7 days, we're like literally growing stuff and making use of it, you guys, or storing it for their future, whatever the case may be. So it is a beautiful thing, a very beautiful, lovely thing, learning how to be self-governed and take advantage of the amazing information that we're learning. So with that being said, we want to give a shout out to all of the people that have come before us and done the hard work and made this possible. Shout out to this brother here, Duval Day, whoever you may be. We appreciate you. We send you love and light always. Thank you for this book. Thank you for the insight. Thank you for just putting it information out there like this, man, because I tell you, it's been a heck of a journey. I ain't even gonna lie, y'all. You know, some of y'all can agree with me. It's definitely been a journey. So I definitely know we're on the right path, because before I came live, I was speaking to Mother Mia Shay, and she was we were talking and kind of like coming back with our research findings, and it's basically we on the same page, y'all. So it's like, hey, we on the right track. We've been on the right track regardless, but now we know for sure that we on the right path. So let me check out y'all. Okay. So with that being said, you all, I love you all. I look forward to meeting more of my indigenous people, as we all family. And I'm happy you all join Freedom Writers. If you're not a part of any other community, feel free to join us and learn and grow together with us as we start figuring out some shit. Okay. And this Tuesday, we're going to be learning about like generating some income out of thin air in the time being, so we won't have to continue to sit around here scraping for pennies. We can have some income being created for ourselves while we go through these processes, so we won't have to continue to contribute to the de facto government and going and having to punch clocks and stuff like that, and not get our just due, like everything that belongs to us. So y'all better come check Freedom Writers out. We doing the damn thing over there. and all my members over there that have been participating. I be clean house and I be kicking people out too, because it's a lot of people that just joined the group, signed NDAs. Like, I'm wondering, like, why y'all signed the NDAs? And at this point, I don't have time for excuses, because people make time for the things that they want to make time for. And I'm not about to go back because you've been gone a whole month or two and try to catch you up. So I'm just not doing it. Like, we all on the same page right now. If you want to join, come join us. Or you can use this book and do it on your own and not have no like accountability partners or nothing like that helping you through the way. So with that being said, it is what it is. That's why I kick people out my group, because it's just like y'all just stagnant. It's like dead weight. And what am I holding on to dead weight for? Because y'all not trying to do nothing. Y'all too worried about your Social Security benefits, too worried about your SSI or whatever the case, you getting food stamps. Like, those are benefits and privileges that like gonna keep you in a de facto. You limiting yourself. So, and I understand, it's hard out here for everybody. I'm not saying I'm better than anyone, because it's a struggle. Every day is a struggle. And I don't work a job, but my husband get out here and go, and he's away from our family 5 days a week, 5 to 6 days a week. And then when he's home, he tries to do his best to be attentive to the family. And we making do with the best that we have right now at this point. But it's not easy all the time. So that's that. I don't have time for people to just be dead weight around me. I don't have time for that anymore. So with that being said, you guys, I love you. I love you, Mother Vicky. I love you. And I appreciate you all as well for your support and just helping me to build my confidence in this knowledge and my understanding in this knowledge, and to be able to help you all grow too. I appreciate you all for that. And I love you all for that, for entrusting in me and believing in me, to know that I'm not taking you down the wrong path, like many of have been taken down in the past. So I love y'all. It is your girl ShayMarie. I will see you all probably tomorrow, because we're gonna get through this book. We got about how many more pages? Let's see here. I don't even chapter 4. Let's see. I know we ended up on like 100 and something. Chapter 4, persons not required to file. Oh no, we ended chapter 4. So we on chapter 5 actually. We doing good. I think we doing good, y'all. Let me get down here. Shouldn't be that many pages left. Okay. Yep, chapter 5 is, we're going to start at 131, eradicating public debt, okay? So tomorrow we're going to go through that. Hopefully we'll be done with this book by the end of the week. That is my goal. That is my intentions. But we all know life happens, but I'm going to make sure I get it done. I'm going to do my best. I'm not going to allow certain things to distract me from that. So if you guys stick with me, I'm going to stick with y'all. So have a great rest of your day, my loves. You all take care. See you all later.